667 Yonge Street on the second floor for part of the Karma Cup Speaker Series.
We're at Vapor Central 2018 Karma Cup Speaker Series.
And we're back to the first annual Karma Cup Speakers Series in conjunction with the 5th annual Karma Cup. And today we're actually going to talk about something that is really important. We are just over a month away from legalization. And we live in a city where a lot of people do not own their own homes, and in fact, they do rent. We also have, so as we're seeing a lot in the news these days, a lot of condo boards, a lot of landlords are now threatening or trying to ban cannabis growing and cannabis consumption on their properties at all. So we have actually got Karima Saad, as she's an up-and-coming lawyer in the cannabis space. She's already working with some really great activists and educators in the space, and as well as from anywhere from patients to recreational users. So she's got a little introspective stuff on law and politics and everything that's kind of made up, the racism that's made up cannabis prohibition. And she is here to talk to us on this very complicated, very important, and very convoluted subject, what it's going to mean for recreational users, what this might mean for patients, and what your rights are as a landlord, as a homeowner, and as a tenant. So thank you very much and welcome.
Thank you, Tracy. So sort of piggybacking on something Tracy mentioned in her introduction, I know that audience participation isn't always the easiest thing in a vapor lounge, but if by show of hands or spirit fingers, can I get a sense of how many people are renters in this room? Okay. And do we have any homeowners? Okay. And here we have it, the competing interests between landlords and tenants. And that is going to be, I think, a prevailing theme in the political and legal landscape after cannabis legalization. So what I hope to do in this presentation is touch briefly on the rights and obligations of both landlords and tenants, and with a view to seeing how the competing interests can possibly be reconciled in such a way that everyone ends up happy and able to make use of their new legal rights to either consume or grow cannabis. Aside from that, I'll also discuss a couple of cases that I've been involved in that have to do with cannabis in the landlord-tenant sphere. And I will then open up the floor to any questions that audience members may have as we embark on this new era of non-prohibition, which is, an exciting change. So starting briefly with landlords and tenants, the obvious factor is, on the one hand, you have landlords who may be concerned about what the legalization of cannabis will bring about. So if the government, the federal government has said 4 plants per household, regardless whether it's recreational or medical use, medical users will continue to have whatever prescription or license they have until such time as that regime is changed. And obviously smoking and consuming cannabis will be legal as well. And what comes with all of these new rights are concerns on the part of landlords that their property will be damaged, or that if it is a more large-scale landlord, that other tenants will be disturbed. And the landlord-tenant game is ultimately a business. It comes down to a bottom line. And while there is a social and human rights aspect to housing, and that's why tenants are afforded a great deal of rights and protections under the Act, the prevailing principle is that it is a business. And from that perspective, landlords have perhaps reason to be concerned about how their business may be impacted. There are a lot of, I think, conceptions, whether they're misconceptions or whether they're accurate, about growing and how having a grow op within a home can create all sorts of damage, be it mold, damage, water, overconsumption of electricity. In fact, there are some insurance policies whereby you must disclose if your house was ever used for the purpose of growing cannabis, and that could have an impact on the sale value of the property or even its insurability point blank. So there are reasons, again, it's not an unfounded fear on the part of landlords that when growing is now allowed at home, there will be tenants who do this in an irresponsible way. And just as an aside, in my own personal practice, I do deal with both landlords and tenants, and so I can vouch for the fact that there are great people on both sides and there are huge jerks on both sides. And I think that the landlords, for their part, are worried about the jerkish tenants because, not done properly, there can be a lot of costly damage that accrues from a grow-op if it's not conducted properly. The propriety is sort of the key issue, though. Tracy mentioned there are condo boards, and condo boards are sort of a separate beast, so we'll get to that in a minute. But there are landlords as well, including Toronto Community Housing in our own city, that purports to say no growing allowed at all, subject perhaps to a medical exemption. And that blanket statement is one that I think will cause a lot of strife between landlords and tenants at the Landlord-Tenant Board. As I said, there may be exemptions for medical users, and I think that in the large scale, it's just as it's medical patients who were the driving force behind legalization. As we develop and figure out and sort out the rights and obligations of tenants and landlords with growing and consumption, again, I think we'll see medical patients at the forefront of these discussions. So just as a point, I think that any sort of ban on either growing or smoking that doesn't include an exemption for medical users right off the bat is unconstitutional and will be challenged. So already there is some leeway, and if a medical user is permitted, then what truly is the distinction between that and someone who consumes for recreational purposes? Why is it that their rights might also be infringed? There's a standard at the Landlord and Tenant Board known as reasonable enjoyment, and that's the bottom line when it comes to assessing whether a tenant's behavior is interfering with somebody else. So if the conduct is so problematic or disruptive or a nuisance to the point that it's interfering with someone else's enjoyment of their home, that's where you could have a problem. And again, circling back to landlords being concerned about grow-ops, you can imagine in an apartment building, if a tenant is growing irresponsibly, they're not really paying attention to water levels, or the plants aren't elevated off the floor and it's bearing a hole or it's causing mold, how that could impact other tenants and not just be a headache for the landlord in terms of their own costs, but affect other people who are also in a living situation, some of whom may have no interest or desire to have any involvement with cannabis. So we have to look at things from that perspective a little bit. And the way of solving this, in my mind, and you'll hear this sort of repeated throughout the course of this presentation, is the idea of mutual respect and cooperation. And landlords, for their part, if you do have tenants, rather than setting out a blanket ban, you may want to establish some parameters. You may want to call for or suggest that there be inspections. If a tenant is intending to grow, that they notify you, that you have an opportunity to see whether it's up to par, if there are going to be adjustments that need to be made to protect your investment, which is the home, as well as the happiness and security of other tenants. So really educating yourself as a landlord about what makes a grow-op potentially harmful or dangerous versus what precautions can be taken to minimize the impact so that it's barely any different than growing a tomato plant, maybe just a bit more work and effort on the part of the gardener, but fundamentally not different than having a home garden. And home gardens themselves can be sources of mold and damage. So again, stepping back from the notion of cannabis as this wildly and drastically different substance or plant, even if it is a unique plant and it is a special one, but it's not inherently harmful or dangerous. And I think that a lot of the hoo-ha surrounding legalization and what's going to happen come October 17th, I think that it'll take some time for people to realize the sky isn't falling, and that a lot of the stigma associated with cannabis really comes from a place of fear, perhaps ignorance, and exposure and normalization. I think the dust will eventually settle. Until then, though, it comes down to mutual respect and cooperation. So we've covered a little bit the notion of growing and a landlord, what proactive measures they can take to ensure their investment is protected. Tenants, for their part, an obligation, again, to not interfere with substantial enjoyment of the landlord or other occupants, being cognizant of how you are undertaking your grow. And the same things that I suggested that a landlord educate themselves, it applies to tenants as well. There are ample resources, whether it's in person at the hydroponic store or online, YouTube, websites, whatever, being aware and mindful of how and what measures you can take to protect the people around you. Smoking sort of falls in it's a little bit different in the sense that it's not it's an intangible almost effect. So the smoke dissipates and it leaves a smell and it can seep into walls. From that perspective, again, a landlord might be cautious about what's going on in their unit. A blanket ban, once again, though, especially if there is no such prohibition on cigarettes, I think would not stand up to any scrutiny if it was brought before a court. The reason I say that is because it's not, there appear to be some attempts to draw arbitrary distinctions between cannabis smoke and tobacco smoke. Again, TCHC has stated, and that's Toronto Community Housing, so the city's largest housing provider. It has both people on subsidies and also market rate units. So it covers a lot of ground in the city. They're saying that in their properties, no smoking anymore at all, period, whether it's cigarettes or not. And I think that them attempting to unilaterally impose this massive change on many people who have been residents for decades, I don't think it's going to fly. And there will probably be challenges. And stepping back a bit, I guess, for those unfamiliar with how the law works in the landlord-tenant area, there is a special tribunal that's designated to deal with any disputes between landlords and tenants. And both sides can bring their own applications. On the one hand, you have landlords who will either attempt to collect rental arrears or money for damage or evict somebody. And then on the tenant side, it's about enforcing rights. And rights that are typically up for discussion are your reasonable enjoyment of the unit. So a landlord cannot harass or pester you or allow somebody else to do that to you. They can't change your locks without your permission. A variety of rights going to your security and peace of mind and enjoyment of the unit. And there's also maintenance obligations on the part of the landlord. So if a landlord isn't keeping things up to par, a tenant can bring them to the board and either request money back for rent or that they actually carry out what needs to be done. Broadly speaking, those are the applications you see at the board. So collecting your rent, evictions, enforcing your rights, and making sure things are repaired and maintained. Where the cannabis and smoking comes into play is if a landlord wants to evict someone for interfering with others, smoking could potentially be one of those reasons if it's at a level where it's not a reasonable amount, or if your lease stipulates that you're not going to engage in that behavior and then you do and it's bothering someone, that could be a reason to end your tenancy. So when Toronto Community Housing says that, okay, no more smoking of anything in our units, whether it's tobacco or something else, they are unilaterally imposing a change on leases for people who have been there for many years. And that's the inherent unfairness of the situation. And again, I think that these types of policies come from stigma and concern and fear about what the world will look like if more people are smoking in their units. And
The fact that these are poorly maintained buildings, and if people keep smoking in them and you keep getting fires, like we are literally losing those buildings.
so no, that is a.
They don't like we'll have time for questions.
I think, and the reason that I say this is because we're talking about changes that are being proposed now. So balcony fires are a very real and valid issue, and for that reason, in my own building, for example, I often see posters reminding you, please make sure you don't ash by just tossing it, have an ashtray, or so on and so forth. But the idea that they're proposing to ban all smoking in the wake of legalization, it suggests that there's a connection between the two, because
Preventive measures.
yeah,
This is really nice.
I mean, yes, preventive measures, but the idea of reasonable enjoyment doesn't just apply to people who don't want to smell in their unit. It also applies to someone who may not be able to smoke elsewhere. And that's actually a good segue to talk about the Ontario Cannabis Act, which is undergoing some legislative tweaking. So we'll see sort of what the final result is, and the Smoke Free Act, because those two combined suggests that there's actually not really anywhere you can smoke if you're not allowed to smoke in a rental unit, and you're not allowed to smoke in public or outdoors, and if they shut down vapor lounges, it creates sort of a pickle for someone who doesn't have anywhere else to go. And earlier we spoke about condos, and I said it's a separate beast, and I would get back to it. Condos are a really interesting situation because there you have a collective living situation, much like you would in an apartment where there's tenants, but you also have individual unit owners, and some of those unit owners have tenants. So there's multiple layers of legal sort of relationships here. You have a condo that's governed by a board, and the board is allowed to make whatever rules for its community that it deems appropriate. Subject, obviously, to whatever constitutional or legal constraints. So if a condo board votes and decides no growing or smoking in our building, then even homeowners or condo owners will have that right infringed, and tenants who might otherwise, in a different circumstance, be able to argue against a landlord imposing this on them won't actually have any real recourse against the condo board because there's no legal relationship there. And I think that that's where we're going to see a lot of litigation. The landlord-tenant board, again, it deals mostly with evictions and enforcing tenant rights. So we will see some cases that come out of there that impact how landlords and tenants relate to one another. But condo is really where we're going to see the meaningful charter, and charter being the constitutional charter of human rights, Canadian rights of charter and freedom. All of those words are just fusing in my head. But in any event, that's where we're going to see a lot of the interesting cases come out. Shifting gears a little bit and talking about from a tenant perspective and what they can expect landlords to do if these rules are imposed and then they try to enforce. The landlord-tenant board is designed in part to protect tenancies. So there are a lot of stipulations on landlords in terms of actually getting someone out. And the application forms themselves are very technical in nature. It requires that's Jesus in the city for anyone who it's so we'll just let that pass for a second. Oh, right. Sorry, it's a parade. I wasn't being facetious. There is a parade currently. All of the roads are shut down. It was such a nightmare to actually get from the west side here today. Okay, never mind. I'll just keep talking then. So I guess at this stage, I might as well discuss some of the cases that I've seen and the trends that I'm spotting so far. I have had a number of medical patients come to me saying that they received a letter from their condo board stating that you must identify yourself if you are a medical patient, and if you intend to be growing, we want, full or unabated rights of access. We'll notify you and we'll come check in, and we have to know at all time how many plants you have, and we want to see proof of your medical conditions, and a long laundry list of things that are very personal in nature. And condo boards are elected from among the general building population, and they're your neighbors essentially, and it's not an individual who's necessarily professional or qualified to make any real determination about your needs as a patient. And so that has been, my office has tried to do some pushback on policies like this, pointing out that the reason for legalization comes down to medical patients who have a right to bodily autonomy and to decide how they medicate, as long as it's within the parameters of what's prescribed by a physician or a doctor, and that's not something that should be up for debate. And there are obviously two sides to this concept. And just as a caveat, none of this is legal advice, but I am trying to shed some light on the considerations that a court might have when deciding whether this kind of notice is valid. So the first thing that a court would look at is, was it following proper board and protocol procedure? Again, there are some technicalities there. Every condo board is a little bit different. But if this was done by way of a secret meeting, for example, or with no real input from the other residents, that it's a material change in issue. So the lack of transparency or participation could be a reason to fight against it. If all is sound and proper, and actually you just live somewhere where the condo community as a whole isn't really open to the idea, then we're looking at the substance of the actual bylaws or rules. And Is there an exemption for medical patients? That's the first question. If there's not, that's something to attack right away, regardless of how you use the plant, because where such an exemption doesn't exist, you're basically posing an unreasonable restriction on something that goes to the safety and security of an individual. And so that Section 7 charter right, going to the really, really fundamental bodily integrity and what you can do and what choices you're allowed to make for yourself. If there is no exemption for medical patient, off the bat, you're going to have a problem. And that's something to challenge. If there is an exemption, then there are sort of two directions you have to take. First of all, looking at the exemption, is it one that is unduly intrusive and infringing on that privacy such that it's not really an exemption at all, it's more of a burden and imposition, and it's still curbing the right in a meaningful way, because if no one feels comfortable participating, then you're effectively denying. So if those regulations are too strict, that could be a line to challenge this. If the regulations are adequate and you're not a medical user, you're just someone who likes to consume or wants to grow or whatever, what have you, that's where we're going to see all types of new cases, because everything we've fought and won so far has had to do with medical. And now that it's a substance like any other, obviously subject to age restrictions, what's the right of a person to do what they want to do in their home? And whether you're a homeowner or a tenant, when you're living somewhere, that's your home. And how much say do other people get to have in what I do in my home if it's legal? Because the legality question is what's different now and then. Because 5 years ago, if you were a recreational user and there was a complaint against you for smoking cannabis in your unit, it's an illegal act. So that in and of itself is enough to potentially get you out of the place. Now that it's no longer an illegal act, I've mentioned the substantial interference. But if something isn't rising to that level and you're trying to ban outright just because, where is the justification for that? And I think that that's going to be the fight that we see in court, and we'll see it in a number of different ways, and not just landlord-tenant. We'll see it in employment law. We'll see it in family law. We'll see it all over the place. But that's what it's going to come down to. And circling back to the notion of preventive measures, and this is a big change in society. Ending a prohibition is a change, and there's no getting around that. And so the idea of coming from a place of caution and let's see how things go and unroll slowly, has validity to it. And that's where I just want to briefly discuss the origins of prohibition, because I think that that's something that's not widely discussed or known, and it may have some impact on the sense of we have to be careful because we don't know what will happen. Cannabis was a perfectly legal substance for most of the history of, let's call it Turtle Island, and it didn't become illegal until the 20s. And leading up to that, there are a lot of historical and political factors that it's sort of boring, but I'll just give a brief overview. In the early 1900s, we saw a lot of immigration to Canada from Asia, in particular Chinese immigrants. And there was pushback to that in the mostly white areas of the port cities. So I'm thinking Vancouver in particular. And that stemmed from xenophobia and racism. So if you take a glance at headlines at the time, they're very dramatic, and there was a huge concern for sort of Asian men ravaging innocent white women and introducing them to opium in particular, because that was sort of the drug that immigrated along with the people. And so there was a report written that basically states that this was a huge social issue and ill. And from that came an anti-opium act that imposed very severe measures against, in particular, Asian men. So it was a targeted piece of legislation. And once that ball started rolling, it extended to other drugs as well. And we saw a similar phenomenon happening in the United States around the same time with cannabis and the Hispanic and Black populations, and it was seen sort of as a danger in that it was a threat to innocence, and that's how it was phrased and framed, and that's where a good deal of stigma gets wrapped up. And in terms of the enforcement laws surrounding cannabis in particular, the racist and systemic origins of that are still carried out to this day. So even though it's used statistically in sort of equal parts across racial demographics, when someone gets arrested for cannabis, it's the officer who has discretion, and that discretion is often applied in a way, and we can see this through. I'm not a statistician at all, but the data generally shows that if you have black or brown skin, you're more likely to be detained or arrested versus let off with a warning. And that also, there's a class element to that as well. If you are in Forest Hill, you will likely have a different reaction of, okay, kids, move along, than if you're found in Regent Park. And I'll just plug a little bit Cannabis Amnesty. I sort of veered off track a little bit. But if you haven't already visited this website or seen this petition, pardon me? Oh, did he? I missed him. Okay, never mind. So I won't be redundant. But anyway, the enforcement patterns really have had a disproportionate impact on racialized and otherwise vulnerable people. And I haven't even mentioned sort of the Indigenous element in Canada, where cannabis, which had cultural significance, was banned, and certain traditions were outlawed in the Indian Act as well, and that was done as a part of sort of cultural stifling. And so where prohibition has these origins and is not actually tied to any science or evidence, and in fact has suppressed the collection of science and evidence, I mean, I suppose that's my basis for thinking that the sky won't fall when we hit October 17th. Anyway, if there, the other type of cases that my office is taking on, there were some evictions that we managed to prevent for a medical patient who was growing. In this particular case, the license had lapsed, and so there was a valid argument that it was actually an illegal act that he was committing. However, the way that he conducted his grow was very responsible, and we managed to have sort of a report to that effect, and where the landlord was alleging that it caused all this damage that it didn't actually cause, we were able to get that thrown out, and he's still there to this day. There's one other case that we're waiting for on a review, again dealing with a medical grow, and here there was a ton of evidence, like 9 hours of testimony that was provided about this mold, and it was a serious mold issue in the unit, but the question was whether the mold started in 2014 before any plants existed, and then whether the plants themselves contributed and caused and made the problem worse. And in the original order, it was found that the landlord hadn't been able to prove that the mold was at all related to the cannabis plants, which had only been there for a short period of time. And again, there was a dehumidifier, and there were daily checks on the humidity levels, and the mold was actually in a different room. On review, however, the decision was quite the opposite, and the landlord submitted a pamphlet from Toronto Police about know if you have a grow-op near you, and it listed some potential damage that could result, and one of the points was mold. And based on this pamphlet, the reviewing member decided that actually, it has the causation has been proven, and it's definitely the mold and the marijuana, they're related, and that's the problem. So he reversed this decision, which gave $10,000 to the tenants, making it so that the tenants actually owed the landlord $3,000. So it was a total flip and reversal. And right now we're at the stage of hopefully overturning that decision. And if it doesn't happen, there's prospect of this going to divisional court, simply because if the review order, which says that for sure, based on this pamphlet, it's the mold and the marijuana, they're related. If that stands, I am concerned of the precedent that will set for people who are growing, whether recreationally or medicinally, and how hard it will be or how easy it will be for a landlord to prove that that's the source of the problem. So I guess at this stage, it makes sense to open up the floor to questions. I guess there's a mic here, so I suppose that's the best way to go.
Hi. Can you hear me? Is it working? All right, I'm David Shirelli. I wear a number of hats here. I write the Cannabis News and Views blog, and also I'm on a condo board, and I was fighting a rather interesting move by our board as directed by its property manager, who's a member of OREA, O-R-E-A, Ontario Real Estate Agency, and they represent landlords and all these other people, and are supposedly, they often advise the condo boards whose buildings they manage too on the issues. And this came complete with a presentation with legalization happening and mad hordes of marijuana smokers running up and down the walls of the building, and all this sort of nonsense. And they developed it's called a rule as opposed to a bylaw for the condo constitution. It's apparently allowed now under the reforms that came, I guess, with the Wynne government, and that still haven't been changed, that would allow any of these rules to be passed by the board, and they would become law unless they were opposed within 30 days by 15% of the population of the building, the owners, I should say. I know it's a little different than with apartments and all that, but I'd like to deal specifically with this issue. Now, I had to kind of improvise and just do this on the fly, and I fought it on the medical pot angle that, they see in court, and also on, the sanctity of home issue, which actually kind of had a broader appeal. But they were trying to grandfather, say, no, it's not a problem, because anyone who smokes or tokes now, they were including tobacco with this too, can declare now, and then they will be exempt, but when they leave the building, their unit becomes available, they sell it or rent it out, then it's a different story altogether. The rule takes place. I said, well, like as a medical cannabis patient, I don't have to you have no right to ask me, kind of flying here, I'm not sure, but to make me sign something that, I'm a smoker or whatever. And I said, when you have people of color, who I don't see any here on our board, are they going to want to step forward and go, oh, yeah, I smoke marijuana all the time, and so do all my kids, right? Like, it's just not a realistic thing. Now, I suspect there was some going back and forth with lawyers and things. Unfortunately, they backed down, and they're going to redo this as a part of some kind of smoke-free law for the building now or something like that. So I guess what I would like to know is what resources are available for people in condominiums that way who may need legal recourse. I mean, I'm sure I can't go to my board and say, let's sponsor you to come in and tell us why this is bullshit, right? But they just
For sure
wouldn't
you
pay-
can offer
I
that.
would gladly, but
I would love to have a guest session at your condo.
well, I'll get your card before you go. I think I have it already. But I mean, I noticed there was a whole. I'm sorry, I'm talking more. I'm supposed to be asking questions here. But first of all, what do you know about this? Do you know any background on this constitutional thing where it can be passed as a rule as opposed to a bylaw for a condo board? And I'm also wondering about OREA, who, by the way, is run by Tim Hudak, who some of you may remember from a number of years ago. Very diabolical figure who's back to make our lives unpleasant. I think it was, yeah, he lost the election by 100,000 job cuts, I believe. But now he's back to pass all these laws. He's got a lobbying group, and you can go Google them or check them on the internet and everything else. And they had a whole little media campaign going throughout Toronto. There were a number of articles. The only one that was sort of progressive I saw was in Now magazine. And then there was one other one that kind of looked at what the impact could be for homelessness, I think, and people of different persuasions and things like that. But it wasn't a real whole lot of research or anything. It was just sort of like a big smear campaign that came out. And I know they were really pushing for these laws to be passed before the Senate vote. And I noticed they're still continuing now. Apparently, a lot of condo boards are still being gunned. And I know in our case they've backed down, but they've retained some other firm, and we're waiting for their latest proposal. So what would you advise on a go-forward basis for people, let's say, not even, I mean, I guess I'm lucky I was on the condo board, I intercepted that one, but for medical or recreational patients in condo boards, what should they do when they find out that, this kind of a rule has been passed? By the way, they sneak things by it. They put you in your mailbox a little notice and say you have 30 days, and most people take the thing and throw it in the garbage without reading it. So don't, and also you're allowed to go to your condo board meetings and all sorts of things too, but most people, of course, don't. So I'm wondering, could you advise us accordingly on what we might do with that?
Well, a lot to unpack. No, that's okay. I mean, in terms of resources, that is a very good question, and I'm actually not aware of anything that specifically caters to that, and that might be a void to fill, because it is sort of an important time right now while it's still new and fresh. So let me think on that and for sure give you a card. But the idea of grandfathering in BC, actually, similar to the OREA, there's a very powerful entity. Their name slips my mind, but there you go, Strata, that takes strong stances and positions. And some of the rules that came out in BC, one of them is that at law, if a lease banned smoking, like that includes cannabis automatically. And that's not the case in Ontario yet. But it is one that will impact a ton of people, I think. And yeah, so lobby groups have power. That's that's the bottom line there. Even to say to organize is kind of difficult because it does again require someone to step out and identify themselves, and there are a variety of reasons why that might not be possible. Sometimes you just wait and see, and then if when a conflict arises, that's the opportunity to really challenge. Because if you do miss sort of those technicalities of the 30 days and now it's settled law and that's that, then when an enforcement happens, you have to fight against that enforcement, just like we have all the criminal law cases which are foundational to legalization. So too we're going to have enforcement prosecution.
Right. You were saying that you thought that a lot of this might be fought out at the condo level. Why was that?
Simply because condos can pass their rules and bylaws, and they function more as a community and co-op, and condos just tend to fight a lot. I think they are prone to litigation in some way. Yeah, so that's just my instinct there, because in the landlord-tenant area, there's unfortunately a lot of people who aren't able to fight it out, and it ends up being more of a routine shutdown.
Okay. Thanks a lot. I'm really glad to see someone taking a lead on this in the legal field, and I'll be in touch with you for sure. Thank you.
Thanks, David.
Yeah, but as somebody that would want to live in this kid-friendly neighborhood, right? Aren't we kind of imposing ourselves upon the public? Like, shouldn't we also be accommodating? Like, as somebody that smokes weed, like, I have no problem realizing that, yeah, you know what, it isn't illegal. That makes it so much better for so many people. Like, why can't we accept that reality right now and then hold out? Because really what I see happening is the price is going up on rent. Like, because this is going to give people a reason to say, you know what, I'm taking additional risk on this. Like, this is illegal. So what is the effect of this on our rental prices? Because if we look at that, so going about it the way you're going about it right now at this time is going to lead to that. So that's more people being pushed out and a specific type of people being pushed out again.
I think just like we can have communities of, and people may opt into a smoke-free community. I think there will also be like 420 friendly landlords, and those might be at a higher premium. But yeah, possibly. But sorry. So your question is,
Why should people that do want to smoke weed, right? Why should they impose themselves upon the public? Like, this is something.
well, I think just by merely existing, though, that's not an imposition. It's sort of the mutual respect and consideration.
And I was, it's more a comment that I'm going to make, and then I have a couple questions. But there are things that cannabis smokers, cannabis growers, cannabis businesses can do. As you'll see along the walls and along the ceilings in here, you've got some pretty powerful carbon filtration air systems. So I keep telling people, if you want to make money in the cannabis industry right now, look into air filtration, because there's going to be a lot of money in that.
Yeah.
But those are also things you can do as a condo tenant, or and I'm sure that there will be people that will come up with that idea. I'm hoping someday this will actually kind of work into my question or my comment. So we're talking a lot about public consumption, landlord head boards. One of the things that, as a patient advocate, I've seen, and it's actually been since January 1st of this year, is that I have a lot of medical marijuana patients that can no longer vaporize or consume cannabis on hospital properties in Ontario at all. In December, they were allowed to medicate. As of January 1st, a lot of hospital policies changed to be in compliance with the Ontario Smoke-Free Act, which has now included cannabis and vaporizers. So what we've got now is that, and what I'm seeing in the news is that there are now elderly medical marijuana patients that are being refused from long-term home care. And that we may actually start to see, so now we have bans in hospitals, and we're also seeing that we may have bans in long-term care homes. Sick people already tend to, so this kind of breaks into a little bit, is sick people already tend to be marginalized when it comes to housing. Do you think medical cannabis patients will now become discriminated against in the housing market?
Legalization brings with it more rules. And where there are more rules, there's more opportunity, to break rules or to be sort of scrutinized. And, the effects that you've described, I do think that medical patients will be disadvantaged. And I don't know if or how that will be remedied in the short term. Appealing to an individual sort of long-term care facility owner is perhaps one thing, but to challenge the legislation in a more substantive way, it requires either political will, and where there are vulnerable groups, usually the political will is somewhat diluted, and there is a challenge, like the charter challenge or a constitutional challenge, taking a law to Superior Court and saying this law adversely affects this group and disproportionately so and unfairly so, and therefore needs to be amended.
Yeah.
And then, that's how we've seen a lot of changes generally in cannabis policy and regulation. So that might be...
Early on in my career, there was once a bylaw sponsored by Rob Ford that was calling, and actually another city councillor who's still on the board, that would call for the fining of landlords if their tenants had grow-ops in their apartments. And Matthew Murnau and I actually went to City Hall and said, okay, well, first of all, what's a grow-up? Is it one plant? Is it 200? What does that mean? But again, it was a situation where it would have marginalized patients that were legally allowed to grow if all of a sudden their landlords were like, well, I might be up to a $50,000 inspection fee from the city in fines if I allow you to grow in my home. So luckily that was abolished and it didn't happen. That was almost 15 years ago. But we're seeing kind of that happen now again, and we're kind of wondering where it's going to fall this time is a bit of a concern. So I'm hoping back to court we go.
It's sort of perverse that ends up being an impact of legalization, that it's actually more difficult, and in that way recreational does screw it up for everyone.
Well, and actually it's the patients that are, as part of the discussions that'll happen is from a landlord tenant from public consumption, patients will be targeted now because not everybody will smoking in public, it'll just be patients, and so therefore they'll be more visible. And we'll see how that goes, whether or not there's actually going to be harassment of any kind. The fact that we are looking at brick and mortar access in other provinces when we still don't have brick and mortar access for patients. Yeah, there's a whole bunch of things wrong with legalization. I love the fact that we're doing it, but we all have some issues if you know the underlying issues of how we got here.
I think as it came to pass, and as it unfolds, it's being more driven by not the interests of medical patients, which is how we got to this point, but more from a sort of a profit and... Yes,
very much is very much my goal has always been dignified access, and unfortunately we're prioritizing profits over patients in the case of legalization. So. That's my own little opinion there, and I guess we agree, but not exactly part of it. The other question I wanted to ask was, we actually talked a lot about the Apartment Act a little bit last year, and that was something that was being introduced by the Ontario government that would ban smoking. And I'm not sure if you've heard anything more about that since?
No, I haven't.
Okay.
I'm not aware of that being legislation?
Yeah, so that was something that was actually in the works last year. They were looking to introduce the Apartment Act that could give the landlords the ability to ban smoking all across Ontario in shared dwelling domains. So I'm kind of wondering if that's still in effect. So I guess we don't know. We'll both look that up.
No, yeah, I've never come across it in any of my cases relating to smoking. So if it has
Good. Maybe that one died too.
If it has passed, they're not enforcing it.
Yeah, because what I'm interested in is the fact that a lot of these properties are not only trying to ban it in the apartments and on the balconies and those kind of things, but actually even in the public smoking spaces.
Yeah.
And as we look at that, even with the ban on public consumption, as a medical marijuana patient, I've always been allowed to medicate where tobacco products were used in public spaces. A private business could absolutely say no to me, and many of those that had liquor licenses did. But public spaces such as Yonge and Dundas Square, they couldn't say a word. So now with that ban on public smoking, I'm wondering if, people like Matt Murnau will get arrested again down at Dundas Square and have to call Paul Lewin to say, hey, I was about to have a seizure, but,
If not arrested, then... at the very least approached and potentially if you have a card and an officer who uses their discretion, then maybe not even a fine, but still that interaction is in and of itself intrusive. If you're trying to just get from point A to point B, and on the way you have to stop and talk to an officer and possibly pay a fine and possibly if you don't have your card with you, be taken to the station.
And as we talked about cannabis amnesty, depending on what your previous interactions have been with the police, that could be triggering in a number of different ways.
Yeah.
So, yeah, if you want to come up and use the mic. Ask a question. But I think they appreciate you in your shoes.
For
Do you want to say it from there?
yes, you can have like time options. So even in a public space, right? Like from the morning time, which is like 8 a.m. or 7 a.m. to 9 p.m., you can have no smoking zones, right? And then after 9 p.m., it can be smoking is allowed. So it creates this opportunity for everyone that wants to use that space to use it, but at the same time, you're not really changing the public day-to-day life right away, because that's going to make a lot of people uncomfortable. And I would rather be polite and kind about this, because we've already got it legalized, and go about it that route than just go about it in a very aggressive manner. So like even time zoning, right? Like there's a lot of solutions like that we can bring about that a lot of people will agree to and be like, okay, yeah, that's fine, cool.
I think in being in any sort of
And
public...
medical is so like that's everything you're bringing up for medical. Those are things that should be like you should never be allowed to get kicked out for medical reasons. So that's a whole different category. So this is just for recreational. Like on the medical side, like yeah, you need to fight for your rights on every single aspect. That's fair. But yeah, I would point that out.
Does anyone else have any more questions? Okay.
I'm just going to ask, do you see from your perspective anything in terms of reasonable access to the rec market kind of coming forward? Do you see kind of any openings there?
What do you mean by reasonable access for the rec market?
With medical, we can kind of access it anywhere we want. Nobody asks a question. Where now you have to, like, with rec, you kind of limit. You can't smoke with college, you can't do this, you can't do that. Whereas legal, it's a legal situation, but you know, you have these bylaws in these cities putting up all these laws.
What we're saying is that we're not even sure it's going to be like, there's going to be harassment for medical as well.
Any other situations going right to the top for reasonable access on the rec side? Because with medicinal, it's a little bit obvious. Like, I need to medicate myself. Whereas the rec side, it's a bit.
So I guess, like, would a recreational user have a court case against public consumption, or maybe home access under maybe Section 7, I guess is what he's asking?
Yeah, I think that potentially. I mean, I'm not even sure it's so obvious that someone medical, it is that obvious, but it's not always that obvious. It then comes down to sort of the individual liberties of a person. And sort of it ties into your question of, you know, can we accommodate by having sort of these time zones or, you know, however you were to structure that. But anytime you're in a public space or living in shared accommodations, you have to expect some level of nuisance, right? Whether it's, I don't like babies and I don't like the sound of them crying and I wish it would stop, or curry powder, or...
Very often the comparison we have when people complain about the cannabis smell, the cannabis user will automatically go around like, well, I don't like it when my neighbor cooks fish.
Right. And so it's you put up with some level of stuff just by being in a society. So that's kind of one thing. And then how do we balance that person's interest of not wanting to be affected by, you know, this change, and then, you know, this change really comes from a place of it never maybe should have been illegal in the first place.
But we're battling against
Right?
almost a century of fear-mongering and prohibition. So, you know, there are people that have families that are like, but the cannabis smoke will get to my children, and my children will go to school high, even though that apartment is 4 doors down and not connected to the same ventilation system, but because they could smell it. So I think, again,
the instinct to protect your children or your family, like that's a good thing. People should nurture that. That's fine.
And so, again, we've talked about is that give and take between your neighbors. It's like, yeah, you know, I'm a cannabis user. If the smell bothers you, and I've done this as a medical patient. If the smell bothers you, let me know. I'll look into air filtration or something to make sure that it doesn't bother you. Because really, an air cleaning kit that you can get for your 1-bedroom apartment is, you know, about the same investment as a volcano. but it'll keep your neighbors happy and you know, may keep your landlord off your back.
Mutual respect and cooperation.
Mutual respect and cooperation, exactly.
And just sort of, you know, on the point about families, please be careful with your edibles and don't be the person who lets
Absolutely.
your, like, because that's going to ruin it for everybody.
Yeah.
Just, anyway, anyway.
Oh yeah. Being safe with your cannabis is an important thing, especially if with your neighbors. We're going to talk about, you know, we'll talk about this tomorrow. There'll be issues with outdoor growing. There's going to be all kinds of issues that are going to come up in the next 5 to 10 years regarding legalization. You are going to be a very, very busy woman. You've certainly chosen the right specialty, I think, is where we're going down along this route line.
As an aside, if anyone has any questions that they weren't wanting to ask, you know, in public, I will be around and I have cards if anyone wants to
Yes, she is on social media. Thank you again so
Thank
much
you.
for battling the traffic to get to us and actually making it. Thank you so much.
And also, if you're anywhere near Toronto, come on down to Vapor Central here for today and tomorrow. More speakers tomorrow.